Good afternoon, everyone. This is Alex Moglia from Moglia Advisors. We want to welcome you to this two-day Memphis fraud seminar. The first day will be this afternoon at 2 p.m. We have the first panel, then the second one will be at 3:15 this afternoon. And then on the 3rd of March, we will have panels 3 and 4, again at 2 p.m. that day and at 3:15 p.m. that day. We want to thank you very much for joining us. We hope you have at least half of the good time we've had in preparing for and this seminar, because I think you'll love it, much as we have loved interacting with each other. I'd like to thank the two sponsors of the seminar, our firm, Moglia Advisors, which is a national financial and restructuring firm, which works with underperforming as well as distressed companies, ranging from seeking to improve the performance of a company, to rescuing a company, to sometimes liquidating companies. And then when things are in really bad shape, we often have to conduct fraud investigations, pursue litigation against insiders or third parties. Third parties could be any number of third parties, but as you'll come to see if you're during the course of this two-day seminar, the parties that may be pursued for wrongdoing or turning a blind eye might well be outside lawyer, in-house lawyers, outside lawyers of a company that's in distress, as well as their outside accounting firms. And in our experience when acting as receivers and bankruptcy trustee throughout the country, we find that we have to often go after outside advisors, which we don't enjoy doing, but sometimes we do. The second sponsor is, of course, the Memphis Bar Association. We can't thank them enough for the guidance, support, and help they provided us. As also, I'd like to thank the Turnaround Management Association for allowing us to use the mailing list of for the Mid-South. But last, but certainly not least, I want to thank our panelists that you'll come to know momentarily for the first panel and thereafter. But I especially would like to thank, the chancellors of Chancery Court in Shelby County, starting with Chancellor Jenkins, before whom I've served and my firm has served, is finishing up acting as a receiver. He was kind enough to appoint us receiver in a case, but also he was kind enough to enlist the help of Chancellors Perry and Kyle to allow us to share and interact with the courts. We'll also, one of the panels will be moderated by Bankruptcy Judge Ruthie Hagan, whom you'll get to know if you don't know her yet. And also just the enormous help and counsel and advice the panelists have provided us. On that note, again, humbly thanking so many people, I turn the first panel, which is called Corporate Ponzi Schemes, to Chancellor Kyle to introduce the fact situation and to take it away. Thank you all. Chancellor Kyle.
Thank you, Alex. I appreciate those kind remarks. As stated earlier, I am Chancellor Jim Kyle of Part 2 of Chancery Court. I have been Chancellor for the last 7 years, and my term expires this year, which will make it 8 years. Before that, I practiced law for close to 30 years in regards to at various law firms in our community. I appreciate the opportunity to participate in this topic, in this presentation, and I've been pleased to have excellent participants in regards to helping me as the moderator of this particular program. I would like to summarize our speakers or as participants as follows. Alex Moglia, as stated earlier, is a founder and president of Moglia Advisors, a financial operational advisory firm serving underperforming and distressed companies in Shelby County, the Mid-South, and nationally for over 30 years. The professionals at Moglia Advisors work as CEOs, CFOs, CROs, and fraud investigators and business evaluators, as well as bankruptcy trustees, receivers, and expert witnesses. Also today on our program, we have Michael Curry, who is a member of Blankler Brown and concentrates his practice in bankruptcy and creditors' rights laws, business reorganizations, workouts, and business and commercial litigation. He has extensive experience in representing bankruptcy trustees and receivers, and also served as a Chapter 11 trustee in complex bankruptcy cases. Finally, we have Hank Shelton, who is a trial lawyer who focuses his practice in litigation and bankruptcy, as well as workouts and reorganizations. He practices with Adams and Reese, where he leads the firm's corporate restructuring and bankruptcy team. So what will be the topic that we will be going forward on today in regards to this program? And that is, the introductory question should be, what is a corporate Ponzi scheme? Not a personal Ponzi scheme, but a corporate Ponzi scheme. And let me give you a hypothetical scenario, if we could, and we'll then be glad to take questions and dialogue. The hypothetical is as follows. Acme Widget Company wants to host a conference of 500 of its employees at an all-inclusive resort in the Bahamas. Maybe we should have had this promise and that we should have scouted that out in the Bahamas when we were getting ready. Acme signs a contract with a corporate event planner, Shady Events, LLC, who becomes highly recommended from the CEO's brother-in-law, whose company has previously used Shady Events for similar events. So you can tell this is a true life summary of a potential event. Shady Events estimates the event will cost $500,000 and requires an upfront payment in order to purchase airline tickets, pay hotel deposits. Acme provides the funds as requested, and Shady Events begins its work. Upon checking with Shady Events 1 month prior to their anticipated conference, Acme discovers that no airline tickets have been purchased or hotel deposits made. And there has not been any for any such time. Therefore, Acme's management team then learns that Shady Events has been doing this for some time, and there is several customers of Shady Events with similar situations. And also, Shady Events LLC and CFO Bill Shady have been traveling in Europe and for dining in fine restaurants, living the high life. Interestingly enough, none of Shady Events clients have had arranged for the events to be in Europe during this time. So questions for the panelists. Let's start with Hank Shelton. How would you advise Acme to proceed, assuming that these are your client?
Hey, give me just a moment. Let me go back just a step. Alex, can you define what we're calling a corporate Ponzi scheme?
Happy to do so. It's actually quite simple. And by the way, this hypothetical is based on one of our projects at Moglia Advisors. We just changed the names to protect the innocent and the not so innocent. Ponzi schemes normally are associated with one or more fraudsters taking advantage and basically stealing money, although they are usually quite smooth about it, stealing money from your typical consumer who is persuaded to invest often their hard-earned money, their hard-earned pension money. Often I've seen it because I was trustee that was appointed to dismantle a fraud scheme where people who had paid off their mortgages and had full equity in their homes were persuaded to take out loans on that full equity and give it to fraudsters. These fraudsters show no mercy. Often they prey not only on those who are of a particular religion, patriotic view, or any number of other, what I would call social affiliations, societal affiliations, and prey on their, and they're just as ready to prey on friends, the fraudster's own friends and family. We created the name corporate Ponzi schemes because we've been appointed or brought into situations where a company takes on monies that belong to their so-called, their customers, to provide those customers a service or a good, often under the claim that they are separating the monies in standalone so-called trust accounts, so that the money from customer A is reserved for customer A, the money for customer B is reserved for customer B, etc. But in reality, these fraudsters use the same concept of a Ponzi, which is take money from one investor or one lender and use it to lavish lifestyles or to pay off obligations or redemption rights on to another customer or investor. And basically they use the same theory, multiplicity of bank accounts, and we just dip money and commingle money and steal money from corporate customers rather than consumers. Thank you.
Let me try to answer Chancellor Kyle's question, assuming I represent Acme, which is suddenly out $500,000. And I think the answer to that is we approach that situation the way any commercial lawyer approaches a question of significant litigation. Obviously, the first thing you do is write a demand letter to Shady Events and ask for your money back. And if Shady Events sends you a $500,000 check, you're done. That's the easy answer. Of course, generally in Ponzi schemes, that only happens, if it does at all, to the very first or second person to be defrauded. And as Alex has pointed out, as the Chancellor referred to in his recital of the facts in this case, we've got a corporate client. Unlike the classic Ponzi scheme, my client in this case is not a little old lady and a little old man down to their last can of soup. They're a business, and businesses do not get the same sympathy that, nor should they, frankly, the same sympathy that courts give defrauded, innocent, and unsophisticated people. Presumably, Acme Widget, if it's got 500 grand to spend on a corporate meeting, is pretty well heeled. So, number one, write the demand letter. Number two, figure out if there's a chance of getting the money back. If there's any chance at all, then of course, you want to file a lawsuit. But before we do that, I think it's important to come to grips with some facts. Acme Widget Company is out $500,000. There's not a commercial law firm in the Western District of Tennessee that is going to take that recovery on a contingent fee. It's going to cost money out of pocket to hire my firm or Mike Borey's firm or any of the other firms who practice in this area. Now, my experience as a longtime practitioner in these courts is these days to just take a very simple kind of bare bones case from filing the complaint in Chancery to getting to a judgment in Chancery is going to cost any client at least 100 grand. In this case, if the case is actively contested by Shady, it could cost more than that. Now, the next thing is just a matter of experience, and I'll go ahead and go there. Generally, a fraudster like Shady and Shady Events has used up all the money or spent it or squirreled it away so that Shady Events itself is likely to be what we call judgment proof. That is to say, we get our judgment in Chancery Court. Chancellor Kyle signs the final judgment, directs the sheriff to go out and levy execution on Shady Event. The sheriff goes out there with his badge and his gun and says to Shady, "Give me everything you got." And Shady pulls out empty pockets. That calls for more remedies that we would talk about later. But essentially, to sum up my answer to Chancellor Kyle's question, you immediately move to demand repayment, assuming there's money to get your hands on. You want to move quickly to litigation to get whatever there is to be got first, before other plaintiffs move in behind you. And if you don't, well, then that leads to some issues that Mike and others will talk about. Thank you, Chancellor.
Is there anyone that would also like to add additional information? I am reminded by the movie The Producers, which I don't know how many of those here watching and listening are, that I'm trying to figure out whether Bill Shady is Zero Mostel or Gene Wilder. Perhaps we can do a poll at the end of the matter on that particular matter. But is there anyone else who would like to add anything to the idea of what needs to be done that hasn't been covered so far when you're starting off?
This is Mike Corey. The only thing I might add at this juncture is obviously you can sue on a simple contract, or if you have sufficient facts at the front end to state a fraud claim against Shady Events. The other thing you may want to do is to, again, if you have sufficient facts, try to freeze the assets of Shady, so there's no further dissipation of assets while you're litigating.
Mike, while we've got you here, would Acme have any potential recourse personally against Bill Shady?
You know, potentially there could be. You know, as Hank indicated, typically when you have these Ponzi schemes unravel, the first one or two people who are on the race to the courthouse might have some success in recovering some assets, or you know, you might have some success without lawsuits, because the fraudster, the last thing they want is to have it publicized that there's a problem. But once things reach litigation level or there's adverse publicity, then the Ponzi scheme, you know, tends to fall apart, because once people are put on notice that they shouldn't do business with Shady Events, then the inflow of new monies that's needed to keep the Ponzi scheme going dries up. So in the context of Bill Shady, he's the principal shareholder of Shady Events, and according to our fact scenario, he has been traveling in Europe for the past 2 years, living lavishly, and all of this is coming from the influx of cash under the Ponzi scheme. So I think there's several ways that creditors such as Acme might have recourse against Shady. First, just under a plain fraud type theory, you know, corporate officers can be held personally liable for actions of the corporation if they actively participate in a fraud. So it's unclear from our fact scenario whether or not what personal representations Bill Shady might have made, but arguably if he had made personal representations which were false and knowingly made in order to defraud Acme, then he might be held liable under a tortious fraudulent misrepresentation theory. Alternately, he could, there are a couple other avenues where he could have personal exposure. One would be for Acme, as part of its lawsuit, to seek to pierce the corporate veil or have Shady deemed to be the alter ego of Shady Events. So in Tennessee, we have, you know, well-established case law on piercing the corporate veil, as well as alter ego. So typically, Tennessee courts will pierce the corporate veil and impose liability, the corporation's liability, onto the shareholder, where it's shown that the corporation is a sham, or a dummy corporation, or where it's necessary to accomplish justice. The case law in Tennessee indicates it's piercing the corporate veil is not something that the court should take lightly. And as a general rule, you need to show more than that it's a closely held company, or more that it's dominated by a single shareholder. You'd have to show that, again, the corporate entity was being used to commit a fraud, and that Shady was involved in it. There's a number of cases out there. The lead cases in the little outline we have of Federal Deposit Insurance Corporation versus Allen. In that case, there's a laundry list of factors that courts can consider in determining whether to pierce the corporate veil. Those factors can include gross undercapitalization of the company, whether there was ever any issuance of stock certificates, the fact that there's a single shareholder, the fact that the corporation is being used as an instrumentality to funnel monies to the individual shareholder or to another corporation that he controls, diversion of assets from the company to the shareholder or related entities, failure to maintain arm's length relationships. So those are just factors that courts consider. You don't necessarily have to prove them all, but generally it's within the discretion of the court to determine whether you've established enough factors to pass the threshold. In Tennessee, if you read through the case law, most of the cases talk about alter ego and veil piercing in the same breath. There's actually a slight difference in them. Sixth Circuit last year, in a case I was involved in, noted the distinction that veil piercing seeks to hold a second party liable for another person's debt, while an alter ego claim asserts that the two parties should be treated as the same party. So under veil piercing, liability is imposed on the shareholder. It's vicarious liability, whereas an alter ego finding basically is direct liability because you're deemed to be the same person. So again, back to the Chancellor's question, could there be potential recourse against Bill Shady? Theoretically, if you have the facts, you might try to pierce the corporate veil or have him deemed to be an alter ego. Another possible avenue would be under the Uniform Fraudulent Transfer Act. Much of the body of case law is involving Ponzi schemes arises under the Uniform Fraudulent Transfer Act, where a creditor or a receiver or a trustee in bankruptcy tries to cast a net and bring back in monies that have been transferred by the fraudster or his corporation. Generally, under the Uniform Fraudulent Transfer Act, again, you can try to trace the money and recover it, provided you meet the requisites of the act. So in our fact scenario, we have allegations that there's been a large funneling of money out of the corporation to Shady to fund his lavish lifestyle in Europe. So to the extent there was no corporate purpose and there was no fair consideration given by Shady for those transfers, then a creditor hypothetically might sue him to recover monies that were transferred to him under the Fraudulent Transfer Act.
Mike, this is Alex. May I ask you a question, please?
Sure.
This fact situation, which as I mentioned, is actually based on one of our projects. We had Bill Shady's company take money from several customers who wanted to have their own separate respective events. So in reality, there were multiple sources of money, and these customers thought that their monies were being kept in separate so-called trust accounts by Bill Shady's company. in your mind, from a legal standpoint, if we have several companies, not only the customer in question here, Acme, but if we have several companies and the monies from those several companies either get commingled with the so-called standalone bank accounts of the other customers. And by the way, in this fact situation, the reality was that the money from several customers then got commingled into one or two, well, let's call it operating accounts. So the money from Acme was commingled with the money from customer 2 or 3. Does that impact your view when the money is commingled and the so-called money is fungible? Does it impact you in representing, say, a creditor that gave Shady money, and now Shady says, well, you know what? It's all mixed in a single pot. I don't know which money is which, and I can't trace it. Does that come into play?
Well, I think it can, and I'll give you an example of a case I was involved in some time ago, but I think to assert a fraudulent transfer claim against Shady, for example, or alter ego claim, I'm not sure that you would have to, that the commingling of funds that in that context would necessarily present a bar. But I'll give you an example of a case I was involved in. Back in the 90s, we had a prominent real estate closing lawyer here in Memphis use his trust account to trade commodities. And he suffered several $1 million loss. And whenever he'd have a margin call in his brokerage account, he would just write a check out of his real estate closing escrow account. So the real estate closing escrow account was similar to what you described with Shady's customers. It was a trust account, sure enough, and presumably he kept track of the accounting like lawyers are supposed to do in their trust account, but there was a shortage in the trust account. So in his case, over time, while he was performing legitimate real estate closings, once the loss in the account got to be so significant, he was using money from new closings to fund payoffs on mortgages for something he may have closed a month or 6 weeks before.
Right.
And so I represented a bankruptcy trustee in that case, and we sued the brokerage company to avoid as fraudulent transfers the margin call payments that had been made out of the trust account. We won. The case ended up getting decided on the issue of the standing of the trustee to pursue those claims. But basically, the Sixth Circuit, we won at the trial level. We got reversed at the Sixth Circuit level. Sixth Circuit said that the cause of action belonged to each of the clients of the attorney, and that they would have had standing to sue the brokerage company to recover their monies. So there is that legal precedent. As a practical matter, though, when you have widespread fraud with lots of money flowing into a same account and being commingled, it becomes very, very difficult for a defrauded customer to show that their money went to Bill Shady, okay? Because if it's in a commingled account, their money might have been partly used to pay the light bill, to make payroll, to keep the enterprise afloat, or to fund the events of the prior customers of Shady who were already in the pipeline. But so yes, it can make a difference, make it more burdensome if you have to prove that your money went to a specific person for transfer purposes.
let me jump in here, Mike, if I can. What we're getting to now is the race to the courthouse stuff. So if you're the first plaintiff there and the first person to be able to grab what money's there as a judgment based on, say, summary judgment for breach of contract, then you're going to take it and run. And to heck with anybody else coming behind you. Now, looking at the hypothetical we've got, clearly Shady did some legitimate business before he got around to
Right.
hosing Acme. So some people got the entertainment venues and corporate parties they were looking for, some didn't. So what you're talking about, well, I guess we ought to expand the hypothetical to if Acme Company is the first one out there, then what about Beta Company coming behind it, which has been thoroughly hosed, but can't get the money because Acme's already got it. You know what? That's where I think you lead into the question about a quality of distribution, which is a goal both of the bankruptcy court and of our chancellors when they're administering cases like this under Tennessee law.
Well, and going back to the cost of litigation, that's why sometimes in these cases, once it becomes known that there's been a widespread fraud, sometimes you'll see some of these smaller creditors recognizing that it's going to be futile to file yet another fraud claim or breach of contract claim in civil court, that they go straight to filing an involuntary bankruptcy petition against the companies in order, again, to get an independent trustee appointed, freeze the assets, and then also potentially trigger some of the avoidance powers that exist under bankruptcy law.
Well, what I would mention this to y'all to think about and be interested in your viewpoint on. Many times it seems like to me on these types of cases, people don't start down the road to be fraudsters. Business isn't very good. We're going to borrow some. We're going to put it back. I need it for this expense, but then I'm going to put it back. And then you put it back, and then that was easy. It worked out. But then it happens again, and then it happens again. People almost become seduced by the lure of unlimited money that's being held in a trust account, and consequently causes it causes them to go down a road of criminal activity where they. I mean, I don't know if Mr. Madoff thought about defrauding all those people when he did his first transaction or not, but I would be surprised if he had. Let's move on, and I think we discussed, quite frankly, the your choice of remedies are a key element in this this area, and I would just be interested, based upon that, are there any well, let me just ask you, Hank, would having a special master or receiver or someone like that in charge of doing all that, is that a viable remedy, or is that just something that might work if you had a $50 million loss, but most folks don't have that?
Well, I think that is a question. Let's assume that Acme got in and got its money first. So you're talking to Beta Company, which doesn't want to put another couple of $100,000 into legal fees. So the first thing they're going to do is ask for a receiver or a special master. At least I would under those circumstances. That way you can spread the pain, so to speak, among all the creditors. So I think that's very, very likely what we do. And it's interesting. I've been involved in a lot of chancery receiverships and a fair amount of bankruptcy work. Most of our chancery receivers are appointed as a matter of contract. At least that's been my experience in Shelby County. Having a receiver appointed to basically collect fraudulently obtained money and distribute it to creditors is clearly within the authority of our chancellors. I'm just not sure how many times they've done it. I don't know, Chancellor Kyle, I'd be curious to know if you've had a receivership like that. I know
I have been affected by receiverships, but not a part thereof, so to speak. And
Yes,
and
sir.
it is, and you're right, it is something we don't do very much. And I have found since I went on the bench that people got to get comfortable doing something before they're willing to do it the first time. I mean, or even the second time. You gotta be used to this, understand that you're doing the right thing, because doing something new is really not what we like. And for those of us on the bench, because we want to be sustained at any court level that we would have on that particular matter. So
I guess I'd cross question this one and ask Alex. I mean, this is the kind of receivership that Alex and Moglia advisors do. So the question is, Alex, could Moglia advisors help in this situation? Pretty clearly, yes, because this is your situation, right?
Yeah, I think logically, the answer to your question, Hank, is yes. Practically is one that has to be examined because a receiver comes at a cost. You can't get something for nothing when it comes to being in court. And a receiver, it has to decide what are the likelihoods of success of retrieving assets. If I can take a step back, when aggrieved parties, usually commercial disputes, come to us and say, and there's an example of a receivership where we were approached by a group of very sophisticated financial institutions who had been fleeced by a scammer. This was a fraud scheme from day one. Money was being filtered out and dissipated throughout the country and outside of the US. And this group of investors and lenders as well, said, we'd like to get you appointed as a bankruptcy trustee. We said to them, there's no way I can get in front of a bankruptcy court fast enough and try to get the money that is disappearing right out under our noses. The next, and in that case, more practical avenue is acting as a receiver, asking the plaintiff or plaintiffs to seek the appointment of a receiver by the applicable court. And the question often is, are the assets within one, let us say one state or one county, or are the assets scattered throughout, say, the United States, or 2 or 3 more states of the United States? And then we say, if it's more localized, it's better for us to work as a state court receiver. If the assets are scattered, it's better for us to work as a federal receiver. Because in a federal receivership, you can, by recording your appointment order, and the appointment orders of receiverships, as Chancellor Jenkins knows from the case in which he appointed us receiver, are encyclopedic, because we've learned from being a receiver that we want very thorough, wide-ranging powers of the receiver. And how do you choose in choosing a state receivership versus a federal receivership? We ask, is there diversity of citizenship between the plaintiff and the defendant? If there is, and there's more than $75,000 at stake, then I think it's more apropos to go into a federal receivership. Even if there's more than $75,000 at stake, just about every case, but the assets are all, say, in Shelby County, it makes all the sense of the world to be in a state court in Shelby County. The other issue that one has to look at when you have, and we've been receivers in corporate situations where consumers were also harmed, is the tension among receivers, especially vis-a-vis law enforcement, of who is the more worthy or empathy deserving aggrieved party? Is it the little old ladies and the little old men who got suckered into this? Or is it, say, a landlord or a bank that funded this company, whether it was a fraud scheme or not? And among federal law enforcement, the natural tendency is to say the little old lady is of higher importance than, say, Bank of America. In bankruptcy, that kind of sympathy doesn't play as much. In this case, if once we know where the assets are, we just start landing and seeking the cooperation of employees, of those that are aggrieved. In one case, all the employees disappeared, all the records disappeared, everything disappeared. We had nothing. So we actually worked with the creditors in compiling basically dossiers on the bad guys and their shell companies. And we began chasing them around the country by going to their banks. And that was a wild scene. But often we have to improvise as receivers to put information together, because the fraudsters are usually pretty good at erasing their tracks. Thank you.
Well, that being said, one of the issues that we seem to come across, the folks who could do the job of a receiver generally have something else to do for a living other than just be a receiver.
Correct.
And consequently, what are the conflicts that you have come across that it has prevented you from getting someone to be a receiver, a quality receiver, but they can't because of they're conflicted by the very nature of the loss?
Well, first of all, when we get appointed receiver, same thing as in bankruptcy, we disclose to the world, to the court, in public filings, whether we've had any kind of tie with any of the parties in the case. In bankruptcy parlance, they call that a statement of disinterestedness. If there is been a contact, like with a law firm or a bank or a company, we disclose it. And it's up to the court to decide whether we are disinterested or not to serve as receiver or bankruptcy trustee. But we disclose it because disclosure is king. One of our competitors, who shall remain nameless, did not disclose certain things to a court. And the court not only replaced that receiver, but clawed back all of the fees that receiver had been awarded by that very same court over the course of, say, a couple of years. So the receiver got fired and his firm had to give back all of what they had been paid because of not disclosing conflicts such as the one you referenced, Chancellor.
Very well indeed. Is there any, Alex, let's try to, we're doing pretty good on our time, and I'm glad to see that. What can companies in Acme's position do to protect themselves from these types of fraud schemes?
Yeah, it's a balance, Your Honor. When I was young, I thought that companies and financial institutions should institute every imaginable directive and prohibition on their employees to do anything either of internal fraud nature or participate in external fraud, either outgoing fraud or incoming fraud, so to speak. And I learned from experience that the more directives and restrictions and policies are implemented by companies, the more where you have the police policing the policed within companies, but the more burdensome that regulation, for lack of a better term, and complex the reporting requirements and the oversight requirements are, the more confused and overwhelmed the employees are. So they just turn off, they disregard it. But it all begins at the top of the organization. If the top of the organization takes fraud prevention and fraud mitigation seriously, not burdensomely seriously, but actively seriously, meaning they do random tests, they do unannounced audits, they do monitor what their employees are saying or doing. They're not just closing their eyes saying, well, we got a pretty fancy internal regulation and prevention, it'll take care of itself by magic. No, it starts always with the top. The top must lead by example. If the top people in our organization, this is more than just fraud prevention, if the top people in our organization don't care, don't expect the rank and file to care a hell of a lot more when the top people don't care. And there are issues of cybersecurity and that we could dwell into, but it's, as somebody once told me, business is simple and solutions are simple. It's whether you have the guts to implement them and lead by example.
Well, let me ask Hank Shelton this in regards to our clients and trying to put the best foot forward. Do we find, is there a difference in the corporate Ponzi scheme nature and the personal Ponzi scheme nature? Or are people just not sympathetic to somebody? Because you can always pitch the greed card at them. Well, if it's too good to be true, it's because it's not so good to be true.
Well, Chancellor, I think Alex, to some extent, illustrated pretty much the difference between a corporate Ponzi scheme and a classic Ponzi scheme based on the victim. And, you know, victims can be interchangeable. So you take where I think everybody's familiar with the Stanford Ponzi scheme that happened right here in Memphis over the last 20 years and wound up with a federal receiver actually in Dallas.
Yeah, Burke Envy.
Yep. And in that situation, there were thousands of victims. Some were personal, some were corporate, some were quite frankly the innocent employees of Stanford who were just selling the product they were given by their boss to sell and wound up having their lives turned upside down and wound up, a couple of them I know unfortunately personally, and just wiped out completely. But in this example that we're given here today, there are no personal victims, at least unless Shady's running, you know, doing a destination wedding, I suppose, for somebody. But if they can afford the kind of money that Shady's talking about, they are not going to be sympathetic victims, right? They are going to be angry business people who've lost money, which is just slightly different from the Stanford situation. So to answer your question, ultimately, fraud, as you know, Chancellor and Chancellor Jenkins and Chancellor Perry, all of you know, you see fraud every day in the Chancery Court of all kinds. Ponzi's are just a particular kind of fraud where the losses can get enormous, as Mike mentioned in the case of the closing attorney. You know, that closing attorney was running hundreds of thousands of dollars through his trust account a month. And it is, as Chancellor Kyle said a few minutes ago, who'd notice if he just borrowed a little bit now and again? And in fact, I think Mike will tell you that the lawyer in question managed to keep it up in the air until we lost power, I guess, in one of the last big ice storm, and he just couldn't make the deposits in time. And then he had personal and corporate victims. So I guess ultimately I would say a true corporate Ponzi scheme would be one that would focus on defrauding corporations who would not have that element of sympathy.
Very well. It's I think our time is coming to an end. I'd like to give all our participants an opportunity to close with with what's on their mind as to an area that we did not cover today that we could think about in the future. So so Mike, why don't you lead us off? Any a watchword that we need to be aware of?
Well, when we're talking about remedies, what we didn't get into is there's really two ways to look at it when you're dealing with a corporate entity, is what causes of action could the corporate entity assert in its own right to try to undo the fraud versus causes of action that belong exclusively to creditors. There's an interesting case, which I cite in the materials I'd refer people to. It involves our colleague, John Ryder, who was a federal receiver in a Ponzi scheme over in federal court involving a gentleman named Bates and a company he had set up to sell gold coins called First Monetary Consultants, I believe. In that particular case, once the receiver was appointed, he sued to recover from the Bill Shady equivalents, the whole family of Mr. Bates and all the companies that he set up under a whole variety of state law causes of action. And in some of these, he stood in the shoes of the corporation. So he had breach of fiduciary duty claims, civil conspiracy, conversion, unjust enrichment, all traditional state law claims that belonged that he asserted on behalf of the company, as well as uniform fraudulent transfer claims. So one of the things that comes up sometimes in this context is, can a receiver stand in the shoes of the company to do that? Because outside of receivership, the company is usually barred. A company that has participated in the fraud is usually going to be barred from seeking its own recovery from its own wrongdoing under the in pari delicto defense, because it's of equal fault. Generally, receivers are immune from that to the extent a creditor can get derivative standing to pursue that claim. It may also be able to stand in the shoes of the company. So again, there's distinct creditor actions, and there's also potential actions that the company could assert. But again, typically you'll either need derivative standing or a receiver or somebody independent appointed to pursue those claims.
Hey, Mike, it's Alex. I'm glad you mentioned the in pari delicto defense. Among the activities of our firm, we act as bankruptcy trustees as well as receivers. And in our experience, when we're pursuing outside insiders, and I would ask if you could address whether the in pari delicto defense can be used, not invoked, but used by, say, an outside accountant or an outside lawyer that participated in the fraud. But we have found that when I'm wearing the bankruptcy trustee hat, I'm pretty much barred anywhere in the country, including in Florida, where we're working on a case right now. We're having a hard time trying to deal with the in pari delicto defense in bankruptcy court. However, when we act as receivers, federal or state, we swing right past it. And this is why on more than one occasion, when aggrieved parties have come to us and say, Alex, we'd like you to serve as a bankruptcy trustee, voluntary filing or involuntary filing. Either the U.S. trustee appoints you or we elect you in as a bankruptcy trustee. Once we begin to get the sense that part of the wrongdoing or all of the wrongdoing is done by an insider, we change to the minds of these people who have called us and said, no, we can't go to bankruptcy court because we're going to run into the in pari delicto defense. However, if we go through a state or federal receivership, we can bypass that defense. So that's something that people in this audience may want to consider, where if there's really more than remorse or more than bad management, if there's really stealing and diversion of funds by an insider or insiders, you may want to consider filing suits in U.S. District Court and trying to get a federal receiver appointed, or in state court in trying to get a state court receiver appointed, because as receivers have a much easier time dealing with the imparo delicto defense. Thank you.
Very, very well. All right. Hank, anything that you want to add to us for today's, as we close down today's session?
Yes, sir. I think getting back to sort of the risk management side of this, the thing to remember for Acme or for any of our clients may not really show up in this scenario that we're given today, because apparently Shady comes well recommended. Other people have used them and have gotten their events. But in a Stanford situation or a classic Ponzi situation, you're offered something that's too good to be true. And, you know, the old cliche is, if it looks too good to be true, it probably is too good to be true. So don't do it. And that sort of gets back to Alex's point of view of how you try to set this up. And, you know, those of us who are on this panel have been young once and are no longer. And we remember, you know, glomming on to some magic tool that was going to work. And I was kind of grinning at Alex's story of that. You know, we've all been around the track a few times, those of us who are on the panel, except for Nate, who's young. But you develop, I guess, after years of doing this, a healthy suspicion of anything that looks good. And you also develop, as I indicated in my opening remarks, a healthy regard for the expense of going and getting these remedies. You know, Mike and I have been around long enough that we can charge rates that to my younger self would seem obscene. And I suppose to some of our clients seem obscene. But it's an expensive process, except for the chancellors. They get paid a state salary. So, you know, those costs are fixed. But the costs of these remedies are substantial. The cost of getting a receiver is substantial. The cost of getting a special Chapter 11 trustee or a special Chapter 7 trustee off the regular bankruptcy panel are substantial. So I think, Chancellor Kyle, to answer your question, I would always look at that. This is a business issue that we're talking about, and you always you know, look at the cost and look at the reward and the benefits before you go forward with any of these remedies.
Well, thank you very much, Hank. I appreciate that. And Alex, do you have anything you want to add in the next 30 seconds?
Just to thank you, sir, for serving as moderator, my colleagues for serving, Hank Shelton and Mike Corey as serving as fellow panelists. I want to thank Nate Jones and Jill Niese for the work they've done. Lauren Gooch, many people within the Memphis Bar Association, and of course I'm forgetting people, but all of a sudden I sound like I'm giving some award speech. So I'll be quiet now, other than to thank you all.
Well, I would hope that everyone watching the panel and participating in the panel today would fill out the questionnaire that is on your screen. I believe, at least it's on my screen, in regards so we can make these type of questionnaires get good information as how we can do better the next time. Thank you very much. As we would say in part 2 of Chancery Court, you're excused.
Thank you.
Thank you, Your Honor.
Thank you.
Well, all right. Good afternoon, everyone, and welcome to this edition of Memphis Fraud Seminar. I'd like to thank all of you participants who are Zooming in with us this afternoon, and would like you to know that if you have questions, you may ask those questions in the chat box, or you can save your questions until the end. This edition of Memphis Fraud Seminar is Help, Our Company Has Been Defrauded. And we're going to talk about what the company and its legal counsel need to do to mitigate fraud and what fraud prevention measures should have been in place when you encounter this situation. Today, I will be your moderator. I'm Jode Jenkins, Chancellor, Part 3 of the Chancery Court here in Shelby County, Tennessee. I've been on the bench now for approximately 6 years. I bring as panelists today, Alex Moglia and Moglia Advisors, who are financial and restructuring advisors and managers who are experts in handling corporate crises. I have the experience of appointing Alex and his team as receivers in the Dexter Solutions case in Chancery Part 3 here in Shelby County. It was a case that was both extraordinarily difficult and extraordinarily successful, and how this company and its team managed this situation. I found the company to be thorough, detailed, and result-oriented in their activities, both outside the court and inside the court. They were very helpful in bringing closure to a case that could have languished on for many, many years and would have caused much damage to many employees and many creditors. Mr. Alex Moglia is a presenter today and a sponsor. We also bring as a panelist, Mike Deba. Mike is a member of Baker Tilly, US, and has over 30 years of experience in financial distress and tax-related matters, including investigations, consultation, and expert witness services. He has served as a chief restructuring officer, a turnaround crisis manager, and a trustee and examiner, court-appointed expert, a receiver, and an arbitrator. Mike also has been retained by the United States Attorney and various defense counsels around the country in criminal cases and investigations. I bring also, as a panelist, Adam Langley. Adam is an attorney and a certified public accountant. Adam practices in the business area where he deals in restructuring. He is a partner with the firm Butler Snow. He uses his accounting and bankruptcy background to help his clients to mitigate risks that are related to distressed businesses, business transactions, and financial instruments, including those resulting from fraud and other malfeasance, and I'd like to say misfeasance as well. Now, let's get right to it. Let's get right to it. You have before you a scenario that will guide and inform our discussion this afternoon. Let me read it for you. During her monthly bank account reconciliation, Jane Smith, a recently hired senior accountant at Acme Widget Company, has identified a $2,000 outgoing wire transfer from Acme's operating account to an unknown account. There is no description on the bank statement as to what the funds were used for. Upon bringing the transaction to the attention of Acme's longtime controller and Jane's direct supervisor, Dave Johnson, Jane is told not to worry about it and that Dave will, quote unquote, take care of it. Unsatisfied with this answer, Jane looks at her prior bank statements, the company's prior bank statements, and finds similar transactions in prior months and years. Each of these similar transactions have been recorded in Acme's accounting system to various expense accounts by none other than, you guessed it, Dave Johnson. Jane is concerned that Dave may be diverting company funds for his personal gain. With that scenario, I'd like to ask you, Mr. Moglia, what in the world would an accountant like Jane Smith do with this situation? What would be her next steps?
Well, she has to tread lightly, carefully, but also decisively. As is often the case in, let's say corporate environments such as this company, you have a subordinate that sees that a superior, in this case a direct, to whom she reports, has engaged in malfeasance or misfeasance, as you say, Chancellor, and can either wait for somebody for Dave, her boss, to take care of it or take other actions. I think there are two levels of responsibility that Jane is facing. Well, three levels, if I think about it. One is, assuming she is a certified public accountant, she will have certain canons of ethics that she has to abide by and act under as standards in her profession. Secondly, she has certain responsibilities if she is, that may increase if she is deemed an officer or decrease if she's deemed not an officer, to be able to protect. She has fiduciary duties to protect the shareholders of the company. And if she sees her boss violating or possibly violating those responsibilities because he, as an officer, would have, assuming he's an officer, controller, that he would have certain fiduciary duties that he has to comply. But the reality is that Jane is very scared, I think. She is uncertain. She's horrified by all of this. She doesn't know whom to go to. And the first question I would ask is this company, Acme Widget, large enough to have in-house counsel? Meaning a lawyer that practices law for a single client, that being Acme. If there is such a lawyer, Jane should go to that lawyer and explain the situation and seek guidance from that in-house lawyer. Let's assume there is no in-house lawyer. She should explain the situation to the outside law firm that this company uses. Let's say that this company, as many companies, choose not to have a law firm on retainer or consult often, because sometimes companies see lawyers and financial advisors such as us as sort of evils that are too costly and are not necessary to be consulted. Then she should be looking above Dave and seeing whoever he reports to and voice her concerns about that as well. So she has concerns that impact her personally, concerns that affect the company, concerns that may affect her status as an accountant. She needs to talk to somebody. Otherwise, this thing that if I hold my breath, according to Dave, things will take care of it. It just usually doesn't work. Things usually get worse.
Indeed. Adam, if you would, do you have any additional first steps for this lady? And if not, then I'd like to have another question directed to you. Do you have any other first steps for her?
Yeah, I think it's going to depend, like Alex said, on the size of the company. But you would hope that even a smaller company, the larger ones are going to have policies put in place, but even smaller ones would have policies put in place. And that's really should be the first place that an employee like this goes, is see what the policies are. What do I do when I get this red flag, this alarm bell going off? Who do I talk to? Obviously here, it looks like Dave is a problem. That may be her direct report. So she's got to figure out how to go around. Larger companies may have a hotline to do that. There's different ways, but that would be the first thing. And you hope there's procedure put in place, or hope there's a way to find that through the company policy, how to get to this information and get to the right person to try to address this situation. Because it is, these situations with fraud become life or deaths for some of these companies, especially if they're smaller. So there is a need to act urgently and to get to counsel and to get, the people in a team that can figure out how to solve and fix this problem.
Now, Alex pointed out that she just might be afraid and maybe like a deer caught in headlamps. What if she chooses not to do anything? Are there any implications of her not doing anything?
Yeah, I mean, it's the thing that everybody doesn't want to have to confront their superior of fraud or potential fraud. So I think there's a lot of emotions that play into that, and a lot of reasons why people don't report that. I think we could all say, we don't want to be confrontational. We don't want to be, aggressive. We don't want to falsely accuse somebody. So I think all those emotions play into it. And that's actually what a fraudster realizes too, and is playing off of those emotions and is trying to keep those emotions to keep other people from checking in on what they are doing. So there's some consequences. I know we had talked about it before as we were planning this. If the ship's on fire and there's no way for her to get help and stop this fraud, at some point you've got to jump off and start swimming. You can't really stay in a fraudulent organization. You've got to make determinations based on what is right and wrong in this situation.
Well, let's assume that she did. I'm sorry, go ahead.
No. I was just going to say, Adam's advice is so good because you would say, well, she should just quit. Isn't that the easy way out? Well, the reality is, easy or not, one way to not be a party or turn a blind eye is to quit. That often sends a message to begin with internally. It protects her. And frankly, we're involved in a trusteeship where I act as trustee in Florida, where a lot of inside employees turn a blind eye. Their outside accountants turn a blind eye. Their outside lawyers turn a blind eye. We sued everybody almost if we didn't settle before we began litigation. Sometimes you just got to get the hell out, no matter how much of an income you're making, because you're just going to get wrapped up into a bad situation. And God forbid, criminal litigation is initiated or law enforcement get initiated, because no income stream in the world is going to make up for going to jail, or like me sitting with federal agents commenting on the sentencing guidelines of how long they should seek to put these bad guys away, as I've done on more than one occasion. It is a sobering, dehumanizing experience, helping decide how many years you're going to try to put a bad guy away or a bad gal away. Trust me.
Right. Well, let's assume, Adam, that she did go to her upper management and disclose this information to them. When then would be the right time for Acme? Let's turn our focus to Acme upper management. When would be the right time for Acme upper management to seek advice of counsel?
They need to do it immediately. I mean, counsel is going to be able to direct them, and obviously, what counsel is going to be important. You're going to need several different people involved, but you want to gain the attorney-client privilege on this. You want to be able to get objective advice that lawyers always provide their clients, or at least try to. And so that's going to be done immediately. You're also going to want to deal with some type of employment lawyer that's going to be able to deal with the fraudster. There are consequences that can come from that. So you've got to be able to, secure all your files, secure all your systems, do all the things to prepare what could potentially be a case or a criminal referral. Those are all things that probably should involve a lawyer pretty much on the front end of this. So, I mean, I think, Alex or Mike would probably tell you that's one of the things they're going to do probably up front immediately as soon as it starts.
Well, tell you what, you've authorized me to call on Mike. Mike, we have a problem. And we need your expertise. Tell me, how would you advise Acme to approach this situation? What do we need to do with Jane? How do we need to handle Dave? What can we do, and how can you help us?
Well, Chancellor, being the bookkeeper in the room and not an attorney, I would say call a lawyer, call counsel first. That is their first call, is to call counsel, as Adam alluded to. Once counsel is called, then how you start advising the company, or how I do it when I walk into these situations, I've walked into several of them, is first off, I read the hypothetical, and nowhere in here did it say that Dave was guilty and that Dave did anything wrong, or that the transactions weren't legitimate. So first thing I would advise is stick to facts, do not make assumptions, okay? And don't talk to anybody until we get the facts. If we have to talk to people to get the facts, do it in with a methodology. And as the materials say, one of the things is document everything from step 1 to step 2, you have to start documenting it. One of the things we do is we start asking for policies and procedures. What policies do you have in place? What procedures? Do you have an outside accountant? If you have an outside accountant, then what do they know? How much of the books and records do they review? Things like that. They will be somebody you want to interview. The other thing is you want to tell the company that although Dave looks like by saying he take care of it, that he may be the target or the guilty party. He may not be, or he may be working with somebody else inside the company, or may be working with the critical vendor, things like that. So you have to gather the facts, no assumptions, do not guess at anything, and you go down the road. The other things, if we had a checklist for this, which there are some out there, the checklist would be to go to the company's insurance policy and to make sure you don't do anything to make the situation worse, and to make sure you don't do anything because if there is a company insurance policy for employee theft, you don't want to do anything to trip that up for a possible denial of a claim later on down the road if we find that Dave has actually taken money or somebody else has.
All right. Well, let me ask you this. If you are in charge of assembling the team, who would you want on the team? Describe the type of people you want on the team. Do you want the in-house counsel on the team? Do you need to bring in outside people, outside accountants, outside lawyers? Do you want Jane on the team? Tell me who's on this investigative team that you're going to assemble.
Well, not Jane and not Dave. So those are the first 2 we wouldn't have on the team. The attorney, of course, whether he's an in-house counsel or outside counsel, a lot of times in these situations that I've been in that they've had in-house counsel, I've asked them to contact their outside counsel too. Because once again, we don't know who inside the company has perpetrated a fraud if there has been a fraud. So we have a lawyer on the team. It depends on the organization, inside, outside, who you have on a team. I like to bring in an outside team. We would bring in a financial advisor or a financial investigator to go through the books and records to say, do these look normal? What's going on here? And so we'd have an attorney, a financial advisor, and then it goes from there. And I think, as Adam said, with the attorneys, you would want an employment attorney there, because the last thing you want to do is make it worse or have the tables turned on you, which I know Alex and I have seen that situation before. So we don't want the company to become liable for something or an accusation that isn't true.
All right. So Alex, we've lawyered up. We have our accountants on board. And before we go much further, is there anything that we should advise Acme upper management not to do at this point in time? Are there any pitfalls that we need to avoid?
Yes, and I would add that when we talk about upper management, we should be talking about, say, the proverbial officers of a company, but also there is spillover responsibilities to the board of directors of the company. And whether if it's a big company or even if it's a small company, whether the owner and the founder is the only member of the board of directors of the company, then it becomes really less distinguishable. But one has to remember that officers of a company serve at the pleasure of the board of directors, and the board of directors serve at the pleasure of the owners of the company. If the board of directors is not aware of everything that's going on, that's a very serious problem for them as well, because often managements, and we all have seen where managements keep a bad situation from the members of the board. and let's assume whether the members of the board include owners or the owners are a third set of players. The board of directors could be deemed liable for some of the actions of the management, because remember, being on the board of directors is not that you go there and you collect your fee and get a good meal, sometimes at fancy places. No, you are the vigilant of the interests of the investors, of the shareholders as a board member. You should have active and regular meetings and obtain reports of any customary or extraordinary events from your officers. So, turning a blind eye or not knowing what the heck is going on is just a poor excuse. We served as the expert witness litigation, one of many, filed against Wells Fargo Bank for the creation of those fraudulent transfers fraudulent accounts you may have read about a few years ago. In the Wells Fargo case, the officers and the directors marched hand in hand in allowing fraud to occur, allowing it to be perpetrated, allowing it to continue, and all the time telling Wall Street what a wonderful growing company Wells Fargo and profitable company Wells Fargo was. And all the time for 5 years, ignoring the directives of the Office of the Controller of the Currency, part of the Treasury Department, US Treasury Department, about grave concerns that the government had about what Wells Fargo was doing and growing inexplicably this pool of accounts, which in fact were really bogus accounts, fraudulent activities. No one went to jail among the top people at Wells Fargo. Sure, some of them lost their jobs, some resigned, some gave back bonuses, all of that, but no one went to jail. Maybe when you're that big, you become immune from going to jail. But I will tell you, in my experience, when you talk about small and mid-sized companies, that immunity from going to jail is far less than if you're a top person at Wells Fargo. So blindness is no excuse.
All right. So let me pivot slightly here. And this question is to you also, Alex. We started out talking about more so defrauding a company as opposed to mismanaging a company, malfeasance versus misfeasance.
Correct.
Sometimes misfeasance can have the whiff or the smell of malfeasance. Do you have an experience in which the mismanagement was so gross such that it almost appeared to be malfeasance? And if you have, describe to us how you handled that situation any differently, if any.
Well, there's an actual case for which I serve as trustee in bankruptcy in Orlando. Not a receivership, but trusteeship, somewhat similar roles as officers of the court. In that case, and this is all public, there was a legitimate business, as is often frauds occur. There's a legitimate business, and for whatever reason, the people in charge feel that they can either raid the cookie jar or engage in defrauding third parties to sustain the growth or the existence of the company. In this Florida case, we had both. You had the principals raiding the cookie jar, taking loans out from the company for hell-bent, crazy investments, but also this company engaged in what we covered actually in the first case, the first session this afternoon, in what we call corporate Ponzi schemes. They would take money from various customers, pool them, mix them, steal from one account of one customer to fund the demands and for payment from the other customer. It was unbelievable, the level of internal and external fraud. We need to always be cognizant, and thus being an officer and director takes a lot of responsibility. And unfortunately, when you have power, often arrogance follows behind it. And so when you have arrogance of power and control of the cash, that's a serious, serious problem. When we get appointed receiver or bankruptcy trustee, first thing or chief restructuring officer, which is an officer position, such as in a situation we've begun right now, the signatures of all the players get removed, and my signature becomes the sole signature on the bank accounts of the company. That's a severe measure,
Wow.
which is increased if then you have the imprimatura of a court behind you, like in the receivership that we handled for your court.
Absolutely. I had that in mind when I posed the question.
Yes,
Mike, tell me, have you had a situation that was similar to the one that Alex described, where you had to have great measures taken in order to remedy the situation or to bring the fraud or the mismanagement under control?
Yes, sir. I've had several. One I will go to is I was called because the company was sure that they were getting defrauded and money was going out of their accounts. And the outside accountant brought it to their attention that their expenses were way out of whack, that their bank reconciliations, the same amounts appeared 2 or 3 times, all the red flags you could think of, definitely something going wrong. There's a fraud here. I got a call. Actually, they called the attorney first, good move. And then I got a call from the attorney to come in. I started looking at the books and records, met with management, and then started going through the process of interviewing people and things. And what I had found was gross mismanagement, gross incompetency. Nobody was stealing but the vendors and the people receiving checks, because they kept loading up these same expenses 2 or 3 times. So they were double and triple paying their expenses.
Wow.
That is a situation in which we all knew it was a fraud. And, it's one of those situations that, you look up at the sky and you say, thank you that we didn't accuse anybody of stealing money, because it was not a theft. So that's where your gross mismanagement can come into and look like a fraud. That's one of the reasons when I spoke earlier that I said we've got to get the facts first before we start accusing people.
Got to get the facts right. Got to get the facts right. Matter of fact, in this case, Acme's upper management is so incensed, is so upset that they are now ready to sue somebody. And Adam, they're coming straight to you. They're saying, "Hey, look, I want to sue. I want to get somebody on the hook for this." What do you tell them? What must be determined before any legal recourse against Dave is taken? What must you determine as a lawyer? What do you have to advise them at this point?
Yeah, so what Alex and Mike both talk about is something that appears like this to be obvious fraud, and then it doesn't end up being fraud. And I think that's the important part of getting your ducks in a row, getting the investigation done in an objective way, in a confidential way, so that when you are ready to bring a case, you have the facts, you have specific allegations that you're required to do under Rule 9 to plead fraud, and you're able to make specific claims that then can be pursued hopefully without a lot of issues in the court of law if you're pursuing some type of civil liability.
So what happens then if you're unable to plead with the particularity that is needed for a fraud claim?
Sure, and I think all lawyers are familiar with a motion to dismiss, and if you don't plead with particularity, you've failed to plead a fraud claim. And so I think there is a requirement to be specific, to have all your facts, to evidence those facts at the pleading stage if you're going to bring a civil lawsuit for fraud. And I think that is mandatory. It's why it's important to get this investigation done correctly. You know, I could throw another example out. Mike and Alex gave one. I had a company that sold off a business segment, and then the new company that was formed out of this business segment had projected certain improvements based on, you know, a certain revenue number that they were going to improve from a cost side and generate, you know, more profits off that. They kept working and working, couldn't figure out why the revenues weren't generating the profits they want. And they turned out it had just been terribly mismanaged by the other company. And when they got in, they were actually, the other company had been recording internal expenses. You're supposed to write those off. They had actually been doing the write-off the wrong direction. And so they took 150 million of internal sales and doubled to 300 million. And so this company had $300 million of sales that didn't exist. And everybody was thinking fraud, fraud, fraud. And it just turned out to be gross incompetence. And so, yes, you've got a civil claim in that situation, but that's a different civil claim than a fraud claim. And so I think it's very important to do that investigation, you know, to make sure there wasn't some type of mistake that can be corrected, and then to do it right. Now, the second item, you know, that's civil. If you look at criminal, that's a different story. I can't prosecute a criminal case. That's got to be done by the government. And so I've got to put together, as my representative of the company, the counsel for the company, a package that I can take as a criminal referral to whether it's the, you know, the local guys, the state guys, FBI, the postal inspector investigates a lot of these things. There's a number of people that want it, but they've got limited resources and they've got a lot of referrals coming their way. And so counsel needs to not just say first thing off the bat, I'm going to make this a referral. They need, again, to get their investigation done, figure out what they're going to accuse, what they think the criminal issue is that they can take, and really have evidence that they take along with a referral so that you're almost doing the homework for those government agencies. They do become interested and do become involved in prosecuting these things.
And Adam, you always tell the insurance company what you're going to do. I've been on the side of more than one denials because they weren't informed timely of the fraud. They weren't, you know, that laundry list of things that they bring up not to pay a claim. The other thing keep in mind about litigation or bringing it to a court or an investigative branch of the government is, Jane is out there. She is the whistleblower, or, you know, she's done it. Jane needs to be careful herself not to be drug into this, because Dave could say, hey, it's the new person. She just came on board. Now, you know, she knew all about this. That we don't want to make her complicit into or have the real fraudster make somebody else complicit in it that's not a fraudster.
Correct.
Your Honor,
Alex,
may
go
I-
ahead.
Yeah, I want to respond to two things. One that Adam mentioned and the other one that Mike mentioned. With regards to, Adam rightly, in my opinion, said that he's not he can't act like a criminal prosecution lawyer. We have learned that when and if a referral needs to be made to law enforcement, it has to be made. What is the old commercial, good wine takes its time? If you're going to make a referral to law enforcement, don't just do it quickly. Take your time, get your facts straight. Whether it becomes juicy enough of a case for law enforcement to get involved is a huge consideration, because law enforcement, like Adam said, is always short funded, and they want a Christmas gift case wrapped up with a big bow with everything investigated and thought through for them to review quickly because they get so many referrals. And I will tell you, in my experience, the more money is involved and the more notable the players that may be the wrongdoers, or the company or the family that owns the company, even if the family is completely innocent, the more likely law enforcement will get involved. The problem is You cannot let law enforcement get involved until you've had enough use of the records of the company to do your job, whatever your job is, as a financial advisor, as a lawyer, as a receiver, as a trustee. Because I learned long ago that if you notify law enforcement too soon, they'll grab all the books and records and the computers, and they leave your client or whomever your client is, either whomever it is, or your creditors, if you're a fiduciary, they take away all the records. And all of a sudden, 8 truckloads of records get carted away to Washington. And I'm sitting there saying, what the hell happened to the records that I need to do my own job as a trustee or a receiver? That's number one. Sorry, it was long-winded on that. On the other side, something that you said, Mike, about notifying insurance, again, experience teaches us one thing or another is, I went from saying, no, well, you need to contact insurance, whatever the claim may be, when you got everything right. Well, you know what? I learned. Now, if anything, we over communicate with insurance companies and put them on notice, even if we have to do subsequent updates to them, because of the thing you said, Mike. If we wait for everything to be nice and pretty to hand over to an insurance company, we may have blown any kind of deadline or statute of limitation or anything. And they said, you didn't notify us long enough. We'll deny coverage because you blew a deadline. And I learned that from experience as well. Sorry.
All right. Well, let me ask you, and this question goes to any one of you that'd like to grab it. Is there a difference in, say, this for-profit company and a situation where it would have been a not-for-profit company, an entity that is not seeking property, and the and the person that was in Dave's shoes is a similar person, a comptroller or a CFO, a person of that nature in this not-for-profit company? Is there a difference in how you would approach that situation?
I will,
Go ahead,
Chancellor, but Alex, I'll take that one. No, numbers are numbers, checks are checks, wires are wires. I would approach it the same. The difference is generally with the nonprofit, there might be different at the management level or at the control level. You would look at them the same. They may be part of the fraud. It's the same thing even with the small company. They may be part of the fraud. So you have to, in my opinion, you have to go in the same. What you don't do is, I'm sorry, the difference would be some of the tax angles. Remember, with the nonprofit part, your expenditures have to be so much to the good instead of to yourselves, or you lose your nonprofit status. And then in a private company, we have to also look, and I know I see everything through a tax lens, but through the tax cycle. And one thing I did want to mention earlier is, in this scenario, management may be the ones perpetrating a fraud. There might not be a theft here. So the $2,000 outgoing wires once a week may be coded to miscellaneous, and they're deducting them on their tax return, and they're taking the cash. So they may be perpetrating a fraud against somebody else, like the Treasury or things like that. So there are those nuances, but you would treat the investigation the same from where I sit.
Absolutely. Adam or Alex, would you like to chime in on that last question I posed? Is there a difference? Would you handle a not-for-profit situation differently than you would a for-profit situation?
I think Mike's right. You probably wouldn't from an investigative standpoint and how you're considering it. The ramifications of what may be different, like Mike said, on the nonprofit side, and on a for-profit side, if you've got a material issue with your financial statements because of the fraud, that's going to require certain restatement of financials. You're in nonprofit too, but you may have bond covenants that now have an extra disclosure that has to go out. You may have to make some type of public SEC requirement filing if you're a public company. So there are a number of other ramifications that could fall out that are going to be specific to a private company and specific to a nonprofit company, just how they're formed and their obligations imposed on them.
Alex?
The only thing I would add is on what both of these fine gentlemen just said is that sometimes you get appointed receiver or trustee in situations, whether they're not profit or not, but that have public policy implications, societal implications. I've used the example of getting appointed for a cemetery where the bodies, the cadavers, are never buried or cremated. They're stashed away in some shed like cords of wood, unbeknownst to the family members who are paying for services, burials or cremations that are not taking place, and the operators are pocketing the money. Sometimes you just, sometimes common sense and your conscience takes over in being a fiduciary, an officer of the court. Sometimes you just got to do things that you hope as a fiduciary you get paid for it, but that sometimes you just got to make sure that society sometimes is more important than any one stream of income, and you just got to do that right and take the job nobody else wants to do and gain control of an out of control situation, often, for instance, having environmental problems. And I'm very cognizant of receivers and trustees being afraid of environmental contamination, for instance, but sometimes you just got to do what you got to do. Somebody's got to fix the situation. And if everybody takes a step backward and you're the one person standing, well, you can't necessarily make money on every gig. You got to do what's right sometimes, no matter.
I'm glad to hear that there are sometimes those situations that come before the court which beg for someone to stand for the public interest or the public good, or for a not-for-profit situation, or an individual that does not have the resources to handle the expense of the litigation or the receivership or special master, as the case may be. So that gives us a good segue into this question. What role, if any, can courts play to assist gentlemen like yourselves in unraveling a fraud scheme or a severely mismanaged financial situation? I'm not going to pick on any one of you, but I will allow the first one that pops up to nab that question. Mike, you're the first one to move, so you get to answer that one.
Thank you so much, Chancellor, for picking on the bookkeeper and not the attorney of the bunch, but that's okay with the courts. The courts can play a significant role in it in discovery issues. I have been in these situations before, and we can't get documents. Sometimes we can't get documents from the banks. Sometimes we can't get, one of the situations I remember is when I was running a bunch of nursing homes, trying to get information from CMS. And it took the courts in order to, I will say, prod CMS and the government in getting us the records we needed to complete our investigation.
Hey, Mike, what is CMS?
I'm sorry, that Medicare, the payer that paid most of the.
It's their administrator, I believe.
Correct. And so the courts are good with that. Also, something about a black robe helps people tell the truth.
Correct.
And and that situation helps out a bunch.
Yeah.
Also controls the situation.
I would say
Adam?
a couple of things that I've been familiar with that are good tools the court can play is, one is just a regular status conference, whether that's monthly or bi-monthly. Let the court not necessarily stay on top of it, but to have the parties come in and make sure that they're talking on these issues. because there's going to be a lot of complexity going on behind the scenes. And sometimes there's going to be fights. There's going to be other things that go on. I found a status conference can kind of bring everybody back to the table, keep things going and keep things progressing. And then on a fraud issue, one of the issues that everybody that deals with fraud runs into is very complex. You've had somebody covering something up, and so it's hard to dig into and figure out what's going on. So that makes discovery a little bit more difficult. We're never in a court situation, or lawyers really want to allow for a fishing expedition. And so there's always this tension of how much should the court allow and not allow. And I would say that's why it's important for fraud to be pled with particularity, because it gives the court more of a signal where it's going to go. And then the courts are usually needing to allow for that kind of flexibility in the joints to say, hey, was this done accurately or not accurately? Was this covered up or not covered up? Those are a little bit harder to investigate and prove through discovery than an ordinary civil case would be.
Alex, you had the opportunity to participate in this litigation in part 3. What are some of the tools that you deployed in that situation that was helpful in getting that situation under control?
First of all, and this is not, I'm not pandering to you, Your Honor. I'm telling you that you listened to us and our concerns as receiver to a very great degree. I've been in front of other courts, either as a trustee or receiver, where some of the courts were simply not interested in what I call the dirty fingernail exercise of forensic investigations, of fraud investigations. While you took an interest in this case, and that was refreshing to me, because I'm involved in another case with Mike where we pursued litigation for 7 or 8 years. We collected $25 million from the bad guys in cash, real money. And I'll never forget the chill I had in me the day we presented our initial argument before a federal court. And when we explained that 250 million approximately had been diverted and stolen, the federal judge, who thankfully was substituted by a new judge eventually, listened to our concerns. $250 million approximately stolen. Incredible fraudulent activity. And I knew we were in serious trouble when the judge sits back in his chair and goes, "Is this why you're here, Mr. Trustee? This is just a collection call, a collection case." I thought I was gonna faint because this reeked. They had all the red flags of fraud, and the judge was really not interested. What we find often is when we start talking about finance and accounting and statistics and financial modeling, many judges are not interested in that. But it's that very gritty work that allows judges, I think, to become even keener for the next case and the next case after that and the next case after that. What you represented was a intellectual curiosity that you had in this case, in our case, which I wish had replicated itself in many other cases across the country. This is why actually we came to you with this idea of the seminar, because you got it. You got it. And we said, can we share this knowledge, the knowledge that Adam and Mike and others have? Can we share it not only with you, your other courts, other judges? Because
well, indeed, we got it, and we appreciate you and what you have done to help us in the way that you were able to recoup funds to pay the creditors in this situation, and how we employed mechanisms to get them paid and to deal with the claims of creditors without wasting an enormous amount of the court's time, which I really appreciate that. So those efforts that you and your team brought to bear were very, very, very good. I see that we're at the 10-minute mark, I believe. And what I want to do at this point is to see if anyone in the audience has a question. If you do have a question, you may unmute yourself or put your question in the chat box to any one of these fine gentlemen. And while I'm waiting on that, I do have another question that I want to pose. Was there a question? No. After all of this, are there any particular takeaways? I know that we have some handouts that will be or have been provided to the audience. Are there any particular takeaways that the audience has? You can give the audience for themselves to take back to their clients regarding any fraud situations or any grossly mismanaged situation. Is there a checklist? Is there a you must do this or you should do this that you would give to your clients? And Adam, I'd like to start with you in responding to that.
Sure. Yeah, we put together some materials. I know all three of us worked on them. There's a checklist out there that we identified, which I would consider more like a guidelines, work you through, think through these issues. We also identified some mindsets that I think are helpful to remind the company, that this is, a stressful situation. It may require resources, may require your time, those type of mentality type of issues. And then I know we put together the fraud triangle, which is a regularly used resource to help think.
Explain that fraud triangle, please.
Sure. So the fraud triangle has three different elements. There's the opportunity, the pressure, and the rationalization. And the idea is that all frauds kind of work in the same way. There has to be an opportunity for the fraudster to come in and manipulate the controls or get around the controls, and they can identify that opportunity. Obviously, the company response would be to put in controls in place the best you can to prevent those opportunities from arising. And then the pressure is what's driving that person to commit the fraud? Is it a financial need? Is it the company pressure they need to perform and their boss is holding them to the fire? What is the pressure? And then the final one is the rationalization. What causes somebody to do fraud for the first time? How do they rationalize it? What is in their mindset? What are they doing to justify in their head? And we found that unless you're just a psychopath, most people tend to have a good rationalization for why they're doing it. They don't consider themselves fraudsters. They consider themselves doing something that's a rational business decision for their own interest, for whatever interest they justify it for, but it's still fraud in that issues. But so it's a good way to kind of characterize and spot fraud and be able to think through, what am I dealing with in a situation?
Alex, I'm sorry, Mike, were you about to say something?
Alex?
No, as far as takeaways is, if you are the owner of a business, or if you are on the member of the board of directors of a business, or you're a top management of a business, don't assume that everything that, however many directives you give, that those directives are being followed. Hold people accountable, hold yourself and your fellow board members and officers accountable. Because if you don't hold yourselves accountable, all the regulations and fraud prevention measures you institute internally are going to generally be ignored by your employees because they don't see top management asking about it, following about it, and leading by example. So in Spanish, we have a saying, when you're running a business or anything like that, you sleep with one eye open and one eye closed when you're running a business. You can never afford to sleep with both eyes closed.
One of the things I tell companies, my friends that are business owners and stuff, is have a preparedness plan. Call your outside accountant. Call somebody to do internal controls. When the fraud occurs and people take money, make sure you have the internal controls and the controls in place to catch it. You don't want it to go for 4 or 5 years.
Right.
And so those are the types of things we tell companies. It's not if you ever, it's when. And be prepared. You have insurance policies. You have this. You have, you call your lawyers on things. You call your accountants on things. Make sure you have a plan, and even if it's a one-page document, what to do. What do the employees do? You want to make sure.
I never asked this question of you, Mike. when would you call the insurance company? And what, if any point, at any point, would you allow them in on your investigation?
I would call them once you've had the discussions with, of course, counsel and the attorneys. And when you believe something is going wrong, then you call them immediately. I have found, believe it or not, that the insurance companies won't come in like some of the agencies do with guns a-blazing. They will let you finish your investigation. And they want you to finish your investigation. But what you don't want to do is lay back and then they ask the question, well, you called DEBA 6 months ago. Why didn't you call us? Because your policy says XYZ, you have this time to report. So the short answer is sooner than later.
In one case and that we handled, we didn't have the money to pursue the insider. Actually, the case I'm talking about was the basis of the hypothetical for the first session that occurred this afternoon. And Nate and Jill Niese from our office and others worked on it. We didn't have the money to prosecute the insider that stole and diverted money. But what we did is the duty of notifying the creditors along with something that Mike Diva just said. So we wrote a report on what we felt were the wrongdoings of the insider. He never thought we'd do that. I'm sure that was his worst nightmare. And then sent that report to all the creditors of the company and said, we cannot prosecute any causes of action. We've already notified the insurance company because we didn't want to blow that deadline, but we don't have the money to pursue litigation against the insider. But you as creditors have the standing and you certainly have the money. So this is the report. It speaks for itself. We sent it to every creditor by email and certified mail. And then it was up to them whether they wanted to invest in pursuing the insider. But then our conscience was clear that we notified the creditors, our beneficiaries of our trust, of the wrongdoings. They had the goods then for them to decide economically if they wanted to go after the bad actor.
And
They
did
chose, one of them chose a little bit. They realized this guy was generally uncollectible, which is a word we use a lot in our world, the world of trouble, uncollectible. And then they just decided after investigating even more on their own dime, I think they let him give him a what is it, a get out of jail free card or something, however the expression is. But the point is, then we as fiduciaries could sleep well at night knowing we revealed the wrongdoing because that was our duty. And had we not revealed the wrongdoing to antagonize, say, the lawyer that referred the matter to us, I might add, we noted him, fired him first and said, your client engaged in wrongdoing and it's our duty to reveal that to the creditors. And if that lawyer never referred a matter to us again, we were fine with that. We did what was right.
Well, we're close to the conclusion of our time. I have a few more questions, but I think we better wrap it up. And the one takeaway that I would like to add, in addition to the ones that you all have, is that we as lawyers and accountants, we have to put our clients in position to prevent the fraud. That means the internal controls that you all have alluded to, the checklist that you all have provided, and understanding the dynamics of what create or gives fodder to the fraud. And so if we will arm our clients with that on a regular basis, annually or semi-annually, I think that they would be in a better position to identify and prevent fraud. There is a poll that the Bar Association, which is one of our partners in this seminar, that has put up and asked that you complete, please ma'am, please sir. That will help us in getting feedback. and making sure that the programs that we put forth for you in the future will be very beneficial to you. We thank you on behalf of Moglia Advisors, Mr. Moglia, Michael Deba, Adam Langley, and Nate Jones, the presenters today. We thank you on behalf of the Memphis Bar Association, President Gibson, and the Executive Director, Mary Upchurch. Thank you very much, and we bid you good day.